Thank you. You may be seated. Good morning. We're here today for oral argument in the case Arizona Bank and Trust versus James R. Barron's Trust. These proceedings are being audio and video recorded, so we would ask counsel to identify yourself at the beginning of the argument. Each side has 20 minutes. If you would like to reserve time for rebuttal, you'll be responsible for doing that. We have read the briefs and we've conferenced this case already. If you would keep that in mind as you argue. But with that, counsel, you may proceed.
Thank you, Your Honors. Good morning. Scott Zwillinger on behalf of the appellants. With me today in the courtroom, Dan and Stacy Warren, Tom and Patricia Tierney, and Jim Barons. I mentioned and introduced my clients today because part of the argument I'm sure that we'll discuss today is how the policy behind Arizona's anti-deficiency statutes apply. Part of the big position by the bank is that this is only to consumers. But they're real individuals, although they are guarantors, and those individuals are part of the policy of the statute. And so I introduced them to emphasize the point that we're not simply here talking about a business entity. We're talking about people. Now, I intend to reserve 10 minutes of my time with your permission, and I'll keep it in mind to make sure I do that myself.
It may be difficult, counsel. Go ahead. Yeah.
I will do my best. But I really want to emphasize the cases that have come after our briefing effectively closed. And those are, of course, the Parkway Bank case and what I'm going to refer to as the Loop 101 case. The Parkway Bank case is pretty darn close and takes us right up to the precipice of this case. And in that case, the court determined that Arizona's anti-deficiency statute simply cannot be waived prospectively. The policy behind that case, although admittedly it reserved the question related to guarantors, suggests the answer in this case. And how do we know that? Well, they jump ahead a couple of months to the Loop 101 case. And although that case dealt with whether the fair market value hearing could be waived, it effectively talked about the question that can borrowers waive the protections of the anti-deficiency statute, and said no. Now, the bank in their brief, or the response brief to the amicus brief, says that, well, that's just dicta and let's ignore it. Well, it's not simply dicta. It is the logical conclusion from the Parkway Bank case. The policies behind the anti-deficiency statute are not simply limited to protecting the homeowner, the borrowers. They are the legislative choice to take away the identity of looking who is the person and to put the policy out there on the state to put the risk of a devaluation in property on the lender.
Can I interrupt you to step back for a minute? Because as you know, we'll affirm the Superior Court if it's correct for any reason. Can you talk about the bank's argument that the statute simply doesn't apply, that 33814G is inapplicable, and you focus on the phrase no action, they focus on the phrase the indebtedness. What does the indebtedness mean?
Well, the indebtedness, it means the deficiency. And the reason that I say that is that this is an action under Section A of the statute. And Section A says, except as provided in F and G.
Wait, back up. What do you mean this is an action under subsection A? Tell me about the nature of the complaint. Help me out. What was the complaint against the guarantors?
It's a deficiency action after a trustee.
It wasn't a breach of contract action?
It was a breach of contract, but it was under the deficiency statute. They could not bring a straight breach of contract action against the guarantors because this is a purchase money loan.
Why?
All the money went into building the houses, and that's the Helvetica decision that if the money goes into the house, this is no debate that it is a qualified residence under the anti-deficiency statute. It's therefore purchase money. So a direct claim on the note could not be brought.
Under subsection C, and I didn't see that actually, quite honestly, that either party had cited or discussed subsection C. I thought that provision in 814 talks about the obligation of anybody who's not a trustor remains on the contract regardless, and it says in an action regardless of whether a trustee sale is held.
But the trustee sale was held. The action was brought under A,
Yeah.
and then A, well, then specifically refers you to G.
Right. It's circular. It goes in a three-way triangle.
Well, I'm sorry.
Go ahead.
I'm sorry.
It seems to go in a triangle.
Well, I would agree with you, except that the language in G is perfectly clear. No action. There's no hedge there. It's very similar, and that's what the court noted in the loop one.
So you're disputing that it's modified by the indebtedness?
Yes, absolutely, Your Honor. Absolutely.
Not modified by the
No.
indebtedness.
It is not.
It's just any action in this world.
It's no action may be brought means no action, and here's how
But what about waste?
Waste is a tort that would be outside this statute. If my clients had destroyed the property in some manner, that's outside the anti-deficiency protection, and courts have held that. But the reason that I say that no action means no action is in the Loop 101 case, there was a comparison made to in the purchase money protection, which says, notwithstanding anything to the contrary, no action may be brought. And this, of course, it's been since Baker v. Gardner 30 years ago that we have to read our anti-deficiency statutes together to affect the legislature's intent. And so when you read those two together, although it's not as, admittedly, not as clear as the purchase money protection, you have to read them together. No action means no action. Had the legislature intended to carve out guarantors or anyone, they could have done it. And there have been decisions of this court, I'm thinking of the Pine Top decision, where the court said, well, we may not agree and we're not clear with the policy, but the statute says what it says, and if the legislator wanted to change it, they could have. And that was 25 years ago, and there's been no change to the statute in response to the opinions of this court and the Supreme
Counsel,
Court.
could I ask, sorry to interrupt, if they, the bank had chosen not to have a trustee sale and had just filed an action against the guarantor, what would your position have been then?
Well, I think we would have argued that after Helvetica that it's a purchase money obligation and the action's barred. That language is, I think, no longer up for debate. It says notwithstanding anything to the contrary.
But Helvetica dealt with purchase money. The borrowers were the homeowners, and that's not the situation here.
That's correct. It's an LLC here.
Not purchase money here as to the guarantors.
Well, I think it is because it's the character. We don't look to the character of the individual. We look to the character of the money. The loan that was made was money built to build a qualifying residence, and therefore we would have taken the position, had that been the case, that it was purchase money and subject to the anti-deficiency protection.
Counsel, I know you said if the legislature wanted it to be otherwise, they would have said so, but isn't the reverse true? You can argue the reverse, can't you? If the legislature wanted this to apply to guarantors, they would have said so. I mean, now we're going 30 years on this statute. Does it surprise you that we don't have this case on the books, the case that we're arguing today?
Well, no, because
It's not on the books. I mean, 30 years of not going after guarantors, I guess.
But I think that there's no choice here, that the statutes say what they say, the decisions of this court and the Supreme Court say what they say, and when the bank goes forward and decides to do a trustee sale, they do so knowing that provision G is there, that they may have been successful below selling an exception which we think is not supported by the statute or the policy, doesn't create that the legislature didn't include it, so therefore it's out. And the reason I also say that again is the two policies behind. We acknowledge that one of the policies, perhaps even the main policy, is to protect the real end-line consumer, the homeowner. But the other policy is how we allocate the loss. And in this instance, the way the legislature chose to allocate the loss is the bank gets the collateral back, they have the ability to hold it, sell it, potentially make their money back, and these folks, the home builders, the guarantors, the individuals, they take the loss of the property and the opportunity to make profit. They had a lot of sunk costs that are never going to come back, and that's a legislative decision that this court and the Supreme Court have always honored. And so if there was a reason to change the statute, or the legislator thought that the courts were incorrect or that the policy was different, they would have done so, but they have not.
So in essence, I mean, and I understand your argument, but you're saying then that there is no reason to ever in the state of Arizona then to sign a guarantee agreement or for a bank to require, in the context of a deed of trust on 2.5 acres or less.
Well, not necessarily. Maybe the money's not purchased. If it's not a purchase money obligation, and even if it's a qualifying residence, then the bank can make the decision.
Funny, because the subsection D doesn't say anything about a purchase money obligation, does it?
Of A14? No, because that's not the purchase money anti-deficiency statute. It would be over at 729. So if I took a home...
Good, yeah. I mean,
if I took a home equity loan or used the property other than for construction proceeds or an LLC or whatever, then it's not subject to protection. The bank then has a choice. Do they take their right to take their collateral non-judicially, or do they go forward and sue individually? That's the decision, and that's the choice they have.
What about the First Credit Union versus Courtney case, which says that you don't even have to exhaust the collateral as to the guarantors, you can just sue them directly? Wouldn't it be an anomalous result for that to be an available remedy, and yet now in an anti-deficiency action, they get the fair market value credit, and yet the guarantors can't be held liable? I mean, that seems a very odd result.
But in that situation where someone was sued directly on the note, they retain the property. So if they have the position the bank that the legislature gave to the banks, where they own the property, they can hold it, sell it, find some way to realize back the loss.
But they could do that here. They could have bid on the property at the foreclosure sale, at the trustee sale.
Well, sure, they could have, and then the bank would have gotten some of the proceeds back. But any third party could have come in and bid at the trustee sale. I mean,
Guarantors have a method of protecting themselves by doing that.
but then they would have to, most likely would have to bid up to the full amount of the loan, because the bank gets up to a full credit bid against the bid at the trustee sale. So although the borrowers, I understand the hypothetical, but I don't think.
Why would they have to bid up to the full amount of the loan? I mean, the bank would continue to bid them up?
Well, if let's say, in simple numbers, if that's okay, let's say it's a $500 loan and the bank comes in, they have the ability to $0 or $1 or $500, they don't actually have to go out into their pocket. They get a credit bid against the property. 501, now someone's going into their pocket. So the bank has that hedge, and maybe the bank makes the decision, at 475 or whatever to let it go. But that's the process after the fact, and that would apply to the guarantors, even if they wanted to separate, or anybody else who wanted to bid at the loan.
It just seems like the legislature's built in, potentially, the argument is made that the legislature has built in a protection, so to speak, for the guarantors under subsection A. They get to go in and they get a fair market value determination, so at least they're not on the hook for the entire, in this case, like $800,000 or $700,000, they get to offset that by the amount of the fair credit bid.
Except when you go back and read what the language of Section G, when it says Section A is subject to Section G,
Good.
and Section G says no action. So I think it's you have to read them both together. And when we look at all the cases, all these statutes are read together, the sections are read together to go through the policy. It's not the statute, I would concede, is not the picture of clarity.
But I guess I start out with what I'm struggling with, me personally, is that this is a section on foreclosure, non-judicial foreclosure under a deed of trust. That's not what we have here. Strictly speaking, we're talking about, I know that happened, but we're talking about a breach of contract action against a guarantor.
But then at that point, it would be purchase money. If we were proceeding on a straight breach of contract, then we'd have a purchase money situation, because these funds all went into the residence. So then, if that was the case, then
Yeah, no, go ahead.
then the claim would be barred equally. And I guess I've gone over what I want to do, but I will. One of the things that I want to emphasize is.
Counsel, if I can just transition back into waiver.
Sure.
Private parties, especially sophisticated parties, okay, and I don't know, maybe you disagree with me on whether your clients are sophisticated, as opposed to maybe a homeowner that's buying a first-time home. Why not give certain individuals in this country the ability to contract?
Well, I think that, again, we have to go back to legislative intent. We have a relatively clean system with bright line rules. If we start, and consistently up until today, except with very limited exceptions, there's been no erosion of how we apply these, not looking at the individuals, not looking the borrower is, who the guarantor is. If we start doing that today, we are going to create a factual mess. Two things are going to happen. What's sophisticated? I'm an attorney. When I buy my house, does that make me sophisticated because I understand deeds of trust and all those things? Is someone not in high school count as sophisticated? We start creating a factual mess. And when we talk about what the bank wants to do here, understand that although they, I guess, lightly tread on this brief and say this would never happen, the moment that we give them an inch, they're going to take a mile. If if this court determines that guarantors can waive this, then when I go to buy my next house, my wife and I are going to be forming an LLC and guaranteeing it. And the bank's going to come up here and say, well, we would never do that, or if we did that, there'd be sham guarantees, and that would be litigated. Well, that's the point. So now, downturn, I have a rough patch, I might lose my house to foreclosure. I've now got to go litigate this issue that it was a sham guarantee. So that's a time and a cost. And maybe that's okay for me because I can represent myself, perhaps foolishly, but what about the people out there? What about these folks? These folks at one time, perhaps they had assets, but okay, at what point do they have sufficient assets that they can defend themselves? And it's those types of eroding away at the edges that courts have stayed away from. And the reason, respectfully, that I think that you have done that is because the statutory language is so clear. No action. And no action means no action. We should not be eroding at the edges. I'm going to reserve my last 5 minutes. Thank you.
Mr. Peck.
Well, good morning, and may it please the court, Bradley Pack appearing on behalf of the appellee, Arizona Bank and Trust. Your Honors, the appellants are asking this court to invalidate a contract between sophisticated parties on the basis of a law that does not apply and a public policy that does not exist. By its plain terms, ARS Section 33814G does not apply to guarantors. It applies only to an action to collect on the indebtedness, which is a promissory note that the subject deed of trust secures.
Let me ask you about that. The language says no action may be maintained to recover any difference. It doesn't say no action may be maintained to recover the indebtedness. It says to recover any difference between the amount of sale and the indebtedness. Doesn't that just suggest no action on this deficiency, period? Why isn't that a legitimate reading of the statute?
Well, because, Your Honor, a guarantee is still a separate contract from the promissory note itself. And if I understand the question correctly, you're focusing on the word difference as opposed to the word indebtedness. But because a contract of guarantee is still separate and independent of the promissory note itself, which is what the statute is referring to, it simply doesn't apply to a guarantee. And you can absolutely have a circumstance where a guarantee has a greater liability than the promissory note itself. For example, even in this case, you have a guarantee that secures not just a single promissory note, not necessarily just a note secured by the deed of trust, but the guarantee in this case secures all indebtedness of the borrower, TDJ, to Arizona Bank and Trust. So you could have, for example, a guarantee that secures 5 separate promissory notes, maybe one of which is the only one that's secured by a deed of trust.
But why wouldn't the guarantee just apply? Couldn't it be harmonized with the anti-deficiency statute by just exempting the debt that goes to a residence that's covered by the anti-deficiency statute, and the guarantee is still in place for the remaining debt?
Respectfully, Your Honor, I don't think that you could, and I think that if you were to do that, if you were going to say, well, we're going to apportion this up, so part of your guarantee is now invalid and subject to the anti-deficiency statute and the other part isn't, I think to do so, you would have to ignore the court's precedent that a guarantee is an entirely separate and independent obligation from the promissory note itself. And it really is the promissory note secured by the deed of trust that Section 33814G is applying to.
Mr. Pratt, could I ask you about a provision of the statute that I don't recall the parties specifically discussing? Judge Brown alluded to it. ARS 33814C talks about 2 circumstances, proceeding not on the deed of trust, but then it says, if, however, a trustee sale is held, the liability of a person who is not a trustor for the deficiency is determined pursuant to subsection A. Does that support your argument, or what's the proper interpretation of that statutory provision? I was just a little bit surprised that neither you nor the amicus talked about it, making me think it doesn't help you, or you would have.
Well, Your Honor, it does help us. And I think it further supports the argument that 33814G, by its terms, doesn't apply to guarantees. What the legislature did in 33814C is to extend certain deficiency protections to guarantors. Specifically, it extended the fair market value credit and the 90-day statute of limitations period of 33814A. Had the legislature intended to extend the no liability provisions of 33814G, then it would have said so expressly in the statute. The fact that the legislature chose to give guarantors certain anti-deficiency protections, the fair market value credit and the statute of limitations, but not others, is even further evidence of the legislature's intent that guarantors were never intended to be subject to 33814G.
And then another statute, and you did very well with that one. I thought I might be giving you a curveball, but ARS 12-1566 E talks about the obligation of a guarantor can be enforced, and it distinguishes between a guarantor and a judgment debtor, which the underlying borrowers would be. Is that statute of any application or interest to us that you know of?
Your Honor, I think the language of that statute tracks very closely the language of Section 33814A in terms of the fair market value credit provisions. So again, I would say the fact that the legislature chose an entirely separate statute to extend the fair market value credit provisions to guarantors, but there is no separate statute that says guarantors are also protected by the zero liability statute of 33814G further supports the legislature's intent. The other evidence, the other thing that you have that supports the argument or the conclusion that 33814G does not apply to guarantors is this court's own precedent interpreting the legislative history of the statute. Going all the way back to Baker, what the Arizona Supreme Court and this court has consistently held is that the anti-deficiency statutes are intended to protect consumers against the financial devastation of losing their own home and also subjecting all of their other assets to liability in the event of a foreclosure.
Wouldn't your client's position, though, simply result in banks requiring to guarantee anytime someone buys a home? And wouldn't, if the borrower has to have their parents sign a guarantee, isn't that kind of an end run around the purpose of the anti-deficiency statute?
Well, if that happened, Your Honor, I think it would be an end run around the anti-deficiency statute. But there is no evidence at all to suggest that that's what would happen in this case. The majority, by far.
But I guess I'm trying to figure out the legislature's intent in adopting these provisions. And if the legislature were looking at it and saying, we want to limit. Couldn't the legislature have been saying we want to limit the recovery for the bank to the amount of the indifference, and we don't want the homeowner to suffer financial ruin, or the homeowner's parents or aunt and uncle to suffer financial ruin. We want to limit the bank to recovering on the difference between the value of the property and the loan.
Well, again, Your Honor, if it was the legislature's intention to protect everybody who might ever possibly have any liability on the promissory note, then I think they could have said that expressly. But they didn't choose to do that. They provided some protections to both borrowers and to guarantors. They chose not to extend the protection of the zero liability protections to guarantors. But one thing that I do want to focus on in your question is you referred to homeowners, and that's consistently what this court has held the statute was intended to protect. Homeowners. The guarantors, who are the appellants in this case, never owned any of the homes that are at issue in this case. They guaranteed a business loan. They were in this to make a profit. The anti-deficiency statutes were never intended to protect business people who purchase homes with the intention of selling them to somebody else and to make a profit.
But the statute doesn't differentiate if someone who otherwise qualifies for the anti-deficiency protections, just a homeowner, and is only going to live in the house for a year intending to try and sell it and make a profit. The statute still applies there, doesn't it?
That's true. The statute does apply equally to both borrowers who are homeowners and people who live in the house as their principal or primary residence. And the statute, when it applies, also applies to developers. I think this court has been clear in the Mid-Kansas decision and the Northern Pine Top properties that, at least on its face, if the statute applies, it protects everybody regardless of who they are. The difference here is the statute doesn't apply at all in this case to guarantors. And that this court itself reached that conclusion decades ago when it decided Long versus Corbett, in which the court held that the statute was not intended to protect the guarantors of a business loan who neither owned the home that was foreclosed upon and who never lived in it or had any other interest in it, which is exactly the case with the guarantors here. On the other hand, I think this issue of does the statute apply in its face and was it actually intended to apply to developers is very significant with respect to the guarantee, with respect to the waiver issue that the borrowers, that the appellants in this case have raised.
Before you move to the waiver issue, Mr. Zwillinger pointed out that there have been some decisions since the briefing in this case. And the Loop 101 case goes through a fairly comprehensive review of the legislative history behind 33814A and talks about in 1988, the legislature added a subsection B, which is no longer in place, which provided for a recovery against guarantors and stated that it was not subject to the time or fair market value limitations. So in 1988 specifically said you can go against guarantors. And then they changed that in 1989, and according to Loop 101, reduced it to a statute of limitations provision. And then it says it moved recovery against guarantors to subsection C, but instead of exempting guarantors from the fair market value determination as it had done a year earlier, et cetera. Have you looked at the legislative history and Loop 101? I mean, because the recitation in that case seems to suggest that the legislature has always intended that guarantors be subject to an action, but with certain protections that have come and gone over the years.
Right, and I have looked very closely at the legislative history, Your Honor, and I think Loop 101 does do an accurate job of capturing it. And the legislative history there is that originally in 1988, the legislature said, you know what, guarantors don't get any benefits of the deficiency action at all. We don't have to give them any fair market value credit. And what that was doing, and I think that was back in the RTC days, is it was giving banks the ability to say, we're going to purchase this property at a trustee sale. We're going to submit a lowball credit bid. Probably nobody else is going to show up and bid on this property. So we're going to get this property back for a very low price, and we can go flip it and sell it ourselves later. But at the same time, we're going to pursue the guarantors for an artificial recovery. And that's what the legislature was intending to prevent when a year later it enacted what's now 33814C, giving guarantors the benefit of that fair market value credit protection. And certainly, and that's, I think, what Loop 101 actually addressed, was the policy behind waiver of the fair market value credit provision. And that simply doesn't apply here. In this case, the guarantors got the benefit of the fair market value credit provision. We stipulated to the fair market value of the property. So the argument that, well, you know, the bank can lowball its credit bid and flip the property and make its money back and still pursue the guarantors for a deficiency, that simply doesn't apply here because the guarantors got the fair market value credit and actually agreed as to what the fair market value of the properties were. It's only the deficiency that we are pursuing the guarantors for. To turn back to the waiver issue for a moment, Your Honor, Arizona law is clear that that contractual waivers are presumed to be enforceable.
Counsel, what about the significance of the Parkway decision from this court just a few months ago?
Your Honor, I think that what Parkway actually addressed was the liability of a borrower under a promissory note. And
Well, understood. I mean, but do you agree with that decision?
You know, frankly, that's putting me in a tough position. But I think with respect to borrowers, limiting it to the facts of that case, I would agree with the result there, that a consumer who's a borrower under the promissory note can't waive the protections of the statute. But that same policy, and I'm also aware that Judge Catani was on that panel, and I actually watched that argument, so I'm very conscious of that. But the court was clear in its opinion to limit its holding specifically to borrowers. And I've read that footnote very closely, and it seems to me there is a clear delineation there between the liability of borrowers and that of guarantors. And that's a very important distinction because the policies simply are not the same when it comes to protecting guarantors of a business loan as it is with protecting consumers under a home loan.
You talked about the policy, and the predominant statement of policy stems from the Depression era, which was to prevent homeowners from both losing their home and then all their other assets through a deficiency. But you see in a lot of our opinions, including Judge Brown and I were on Helvetica, and we echoed it, although I've since come to believe this may not be exactly financially accurate, that a second policy consideration is that you should put the onus on the lender and not the borrower because the lender is better able to protect itself and to forecast market changes, et cetera. What about application of that policy argument to the situation with guarantors?
Well, I think that excluding guarantors from the scope of the statute is completely consistent with that policy. As I've read the decisions by this court, the language that's generally used is that the statute shifts the risk of inadequate security for the loan from the borrower to the lender. That's still consistent with enforcing a guarantee because a guarantee really is just additional security for the loan in the same sense that getting a deed of trust on other property would be additional security for the loan. And there's no question that the anti-deficiency statute allows lenders to pursue any other security for the loan that it has, even aside from the deed of trust on the subject property. If the court were to adopt a contrary policy, or it said, essentially what the appellants are asking the court to do is as Judge Brown suggested, ignore these commercial guarantees, because in this context, a commercial guarantee by a bank would be entirely meaningless. The bank would never be able to enforce it, so there would be no point in asking for a guarantee. If the court were to adopt such a policy, I think what you'd find is there simply wouldn't be loans made to finance the construction of developments, because the bank, when
What about Mr. Williams' argument that it only applies to purchase money mortgages? It only applies to purchase money loans. And so any loans that, for development and business loans, those are rarely going to fall within the purchase money description, right, counsel?
Well, actually, Your Honor, first of all, this case does not involve a purchase money loan, and that's incorrect. This case arises out of an acquisition and development loan that Arizona Bank and Trust made to the borrower, TDJ, to purchase and to develop an entire 22-lot subdivision in Gold Canyon. The guarantees that are at issue in this case were signed in connection with that acquisition and development loan to buy and develop, put all the infrastructure in to this entire subdivision, although the guarantees by their terms.
So you agree that it applies to the borrower, that the anti-deficiency statute applies to the borrower on this loan. Is that accurate?
Yes, and that's why we stipulated to dismiss the borrower as soon as we conducted the trustee sale in this case.
So why couldn't we interpret the guarantee as guaranteeing what you've agreed is subject to anti-deficiency, at least this aspect of the guarantee?
Your Honor, I'm not entirely certain I understand the court's question, but the primary obligation is subject to the anti-deficiency statute, at least on its face under 33814G. If that doesn't answer...
Isn't the guarantor guaranteeing the primary obligation? I mean, the primary obligation is to pay the debt, pay the note, right? And then if it defaults, then give your house up. And I think, I don't know, maybe you're on a different or line of thought here, Judge Kennedy, but I'm reading the question as, isn't the guarantor simply guaranteeing or sort of stepping into the shoes of the primary obligor? What's wrong with that argument?
Well, the guarantor is not stepping into the borrower's shoes because, again, a guarantee is a separate and independent obligation. But one of the obligations that was guaranteed in this case certainly was a promissory note that the deed of trust, which was foreclosed, secured.
But your answer is the guarantors are not vicariously liable, and so the dismissal of the actual borrower doesn't absolve them of liability.
Absolutely. And you see that all the time in, for example, bankruptcy cases where the borrower files bankruptcy. The borrower may be discharged of its obligations, but because the guarantee is a separate and independent obligation, the lender still has a right to pursue the guarantor. One last thing on that track, as long as we're talking about the difference between borrowers and whether this is a purchase money loan, the appellants assert that, well, we wouldn't be able to pursue them regardless of whether we foreclosed under the deed of trust statute because 33729A would apply. That's not correct either. First of all, what's interesting is 33729A does expressly say that these anti-deficiency protections apply notwithstanding any agreement to the contrary, which you do not see in 33814G. But the other thing about 33729A is it says that the lien of judgment against a judgment debtor in a mortgage foreclosure action shall not apply to any other property of the judgment debtor. Well, the judgment debtor in a mortgage foreclosure action is going to be the mortgager, which is almost always going to be the borrower under the promissory note, not any guarantor. That further supports the conclusion that 33814G does not apply to guarantors. Your Honors, I see that I'm out of time, so unless the court has any further questions, I'll conclude.
Thank you.
Your Honors, with your permission, where I want to start is talking about, make sure we're clear about the loans we're talking about here. The waiver of and the guarantee is in a land acquisition loan that has been paid off. The action that was brought in this case was under a separate loan that was a construction loan. That loan, I don't think it can fairly be disputed, is a purchase money loan and is subject to anti-deficiency protection under 729. So when we talk about waiver, and my point earlier about Parkway Bank brings us to this case, the panel here doesn't actually have to decide that question because the loan where the waiver of the anti-deficiency protection was has been satisfied and discharged. In addition,
But this new loan, they incorporated the previous provisions from the prior loan. Is that accurate?
but not with the language, they don't sign a new commercial guarantee that contains the waiver. And when the waiver was made in the first loan, that property obviously was not subject to anti-deficiency protection because it was, it was more than 2.5 acres and was not not a residence. So you're having a situation where someone is waiving a right that doesn't yet even exist then, that loan is satisfied, and now we're trying to carry over that waiver when a loan exists. Does that mean that if one of these individuals went out and bought a new house from the bank, that waiver would apply? So it would go into eternity. It starts to be ridiculous. So at some point we don't even, don't have to answer the question because in this circumstances that loan's been released. I want to talk about the statute, and starting with 814C, I agree, and we have the exact opposite perspective from the bank. This makes it clear that a guarantor, you kick up to A, they're subject to the protections. It doesn't say subject to everything in A except for the first sentence that says you look at G. So you start at C, it says you go to A, and A refers you to G in a limited circumstance. So for example, were this a straight commercial building and a foreclosure occurred, what C says is you look to A against the guarantors. It would not be subject to the protections of G because it's not a qualifying residence, and therefore you go forward. But in this instance, when the property is undisputed that it's a qualifying residence, you start at C, kick up to A, but now you have to look at G, which says no action. And going again to the point that I agree that 729, the purchase money obligation, is clearer than 814. It says notwithstanding anything to the contrary. But in the Loop 101 case, it, again, acknowledging that for 30 years we harmonized the statutes together, and it said no action means no action. Had the legislature wanted to say no action except for guarantors or anyone, they could have and would have said it, and they certainly have had enough guidance from this court and the Supreme Court that this is an issue, and yet the statute has not changed at all. And we talked a little bit, very briefly, counsel talked about the Northern Arizona Pine Top case. And that case is also more than 20 years old. And in it, again, the court acknowledged that someone who does this for business for profit is still subject to the statute. Again, giving advice to the legislature that they could change it. So again, the fact that these folks originally wanted to profit from this is irrelevant because of the language of the statute. And if you accept the position of the bank, again, then we're going to end up in the situation where we're going to have lots of fact findings by the trial courts to determine when a profit occurs. If I buy a house and then leave my house and rent it out because I decide not to sell it, I'm now possibly getting a profit. Am I outside the protection? Now, if I'm a borrower, yes, but if you sanction that guarantors can waive it when when it happens and now I'm guaranteeing, or my father or my uncle or whoever is guaranteeing the loan because I rented it for profit, now I'm not subject. And that creates the chaos that for 30 years the courts of the state have refused to engage in. I want to talk very briefly about Long versus Corbett. This is the case that the banks hold on to with two hands, and it is, first off, an outlier, and it is factually so distinguishable as to should be disregarded. In Long versus Corbett, the gentleman who guaranteed a business loan, and it was a true business loan of cash to a business, and one of the other guarantors also put his house on the line, but he had the gentleman who was being sued had no interest in the house. Here we have three families who are members of an LLC, the only members of the LLC. The LLC owned the houses at one time. They absolutely had an interest in the house. In that case, it is an outlier and factually so distinctive that respectfully I think you should disregard it. Okay, I guess my time is up unless you have any further questions. Thank you very much.
Thank you. Thank you both, counsel, for your arguments. We will take this matter under advisement and issue a decision in due course. We will take a brief recess, prepare the courtroom for our next argument. Thank you.